Ms. Huey, you are here today, and my understanding is that you have filed, again, representing yourself pro se in this case as well, that you have filed a series of motions, one of which is to establish a buyout procedure, authorize a transfer of interest, and to impose deadlines, motion to compel responses to requests for production of documents.
Yes, sir.
I'm going to allow you to have an opportunity to argue your motions if you want to address the first one, which is the motion to establish buyout procedures.
Yes, sir. Your Honor, I'm seeking disentanglement and finality in exiting this ownership relationship. I've been displaced for nearly a year and continue incurring approximately $2,500 a month in housing costs while my equity of over $250,000 remains tied up and the timeline continues to expand. I'm requesting a structured path forward that allows resolution rather than continued expansion of timelines and uncertainty. The current processes involve multiple personal property auctions while the real property, the primary asset, remains without defined listing timelines or endpoint. I'm simply requesting a structured buyout process and the ability to transfer my ownership interest with successor recognition so a purchaser may step into my shoes without disrupting proceedings or prejudicing the proceedings at all. I also have a 13-year-old child, and the prolonged uncertainty is directly affecting my ability to provide stability and move forward.
But this is a case that the court has heard motions in before, and I think there's already an order down that ordered that the property be placed for sale, and that it listed the method by which we're doing it. So you're actually asking me to change the prior order of the court, but so far all I've heard is you're asking to set some sort of structured transfer process that would be more expeditious, but how exactly are you proposing that that be done other than by selling the property by realtor?
So Judge, I'm asking that if I'm able or if I have the opportunity to sell my interest to an investor or third party so that I may exit the structure and the structure that you set forth for selling the property can continue and someone simply step into my place.
Well, I don't think there's anything that would prevent you from selling your interest to a third party, but the third party would have to be advised that there's ongoing litigation and that this case has already been, this is a partition suit, which means that owners of property that no longer wish to be co-owners of the property have an absolute right to partition the property. There are two methods by which the property can be partitioned. One is by partition in kind, where you divide the property up equally in value, and real property is oftentimes very difficult to do that. Well, this is a house, is that correct?
It is a house.
Yes, sir.
So it's very difficult to arrive at a partition in kind, which means the only other way is by selling the property. You have an interest in the property. If you want to sell your interest to a third person, then you can do so as long as it doesn't complicate or restrict what happens in this case, because we already have a court order that sets in motion the sale and liquidation of this property.
Yes, sir. Thank you. I just wanted clarity from the court that that process would be allowed and that those successor rights could pass.
Let me hear from Mr. Osborne, who represents the other parties. Mr. Osborne, you may need to, the prior person was a little shorter than you are, so.
Thank you, Judge. Your Honor, Ms. Huey's got multiple motions that she has filed before the court, so I'll address both the motion to establish the buyout procedure as well as the motion to authorize the transfer of interest that she has filed. Judge, as you have rightly pointed out, the court heard a prior motion in this matter on February the 12th of this year. During that motion, which was a motion to authorize the auction of the personal property as well as the listing of the real property, the personal property being auctioned with Mr. Neil Trice and the real property being listed for sale with Ms. Beth Thornton and Ms. Carrie Carrington as co-agents. Now at that time, Judge, there was no opposition stated by Ms. Huey. In fact, everybody announced that they were in agreement with this proposed course of sale. That order entered, it became final. There was no opposition, no appeal filed to that order. We would just ask that that order be left in place, that the process be allowed to carry out. I did speak with Mr. Trice this morning. He said the first auction of the personal property took place this weekend. He said that it went very well, had a great turnout. Several items were sold. The second auction of the personal property is scheduled for July 11th, I believe, this summer. Once that is taken care of and the personal property auction is completed, at that point, Ms. Carrington and Ms. Thornton can proceed with getting the property listed. Respectfully, Judge, we would ask that the parties just maintain the status quo and allow this sale to go ahead and take place. Marketable title has got to obviously include any co-owners signing off on the listing agreement. Ms. Huey had previously indicated she was fine to list the property with Ms. Thornton and Ms. Carrington. They've both spent a decent amount of time, as I understand, going out, viewing the property, making recommendations on what needs to happen for showings. So we would ask that, again, the court just allow the existing order to stay in place, that the parties not make any transfer of the ownership interest, and that whenever this personal property auction takes place in July, the parties can then immediately list the property with the agents, and hopefully it'll get sold pretty quickly. This is in a good area of the county. It's just off Spencer Mill Road. That area has historically done very well, especially here in the recent few years. I think the property will do quite well, but again, Judge, we would ask that the process be allowed to play out as set forth in the February order.
This courtroom battle was over a house. Ms. Huey says she's paying $2,500 a month while her money stays trapped in the property, so she wants to sell her share and get out. But the other side says not so fast. The court already approved a sale process. Auctions are underway and realtors are ready. The judge keeps it simple. She can sell her interest, but she can't stop the court-ordered sale. What do you think? Fair or frustrating? Like, comment, and subscribe.
All right. Ms. Huey, the problem is that there's already an order down that establishes how this property is to be sold and liquidated and how the partition is to go forward. And that order went down and more than 30 days elapsed from the entry of the order. So therefore, under the rules, that becomes an order that's a final order. As a result of that, I am not going to make any changes in that procedure because of the fact that making a change in it would simply delay the process that we've already entered into. And I think that the process that we're engaging in right now is the best and most efficient way to liquidate this property and to try to obtain the best and most valuable price for the property for all concerned. Now, Mr. Osborne raises a point because Mr. Osborne's firm deals with title searches and so forth, and he's well aware that while I indicated that there was nothing that would prevent you from liquidating your interest and transferring it to some other party, the problem is if you were to do that and it were to interfere with the transfer of the sale of the real property because it complicates the title, then by allowing you to liquidate your interest, it complicates and restricts and makes more difficult and more expensive that interest that the process that we're engaging in to try to liquidate this property. For that reason, I am ruling that the prior order of the court as far as how this property is to be sold is going to be the order of the court that will take full force and effect, and that there will be no changes and that no party will be allowed to transfer any interest in the property until such time as the real estate property is, in fact, under contract to be sold. What that does, I think if we have an auction of the personal property, then the real property becomes much more marketable, and then I think that you'll see that there's a much better price that is. I understand your economic situation, but your economic situation does not require the court, unfortunately, to restrict the rights of the other parties that are involved in order to perhaps aid you in your situation would be detrimental to the remaining parties of this lawsuit. And for that reason, I cannot grant your request to allow you to liquidate your interest, transfer your interest to some third party that would then complicate the transfer of title at the sale of the property. There is a motion to compel responses to requests for production of documents. Is there?
Judge, if I could just address that briefly. This is Ms. Huey's second set of discovery requests that she has sent to us. She does have a set of discovery requests from us that still needs to be sent. The pending discovery from us includes a set of requests for admissions. Her second set of requests for admissions, I believe that was 95 that she sent on the second request.
95 requests for admission?
Yes, sir. That she sent to us. We have coordinated with Mr. and Mrs. Sproles. We've compiled answers to those. We had made efforts to get those executed electronically via DocuSign. Mr. and Mrs. Sproles were having issues with their email. Ms. Huckabee, one of their other daughters, who is also their attorney in fact, has met with me this morning right before court. She has executed those requests for admissions. I will be getting those over to Ms. Huey following court today. There is also a pending set of requests for production of documents. Judge, this is a rather voluminous file. That box contains all the documents we are trying to go through and compile, but again, given the volume of documents, we have not been able to get those over yet. We anticipate getting those done in the upcoming weeks. Mr. Belmars did file a response proposing a scheduling order if the court thinks that's necessary. But again, the other set of discovery requests, we intend to get those out to her as soon as we can.
Well, Ms. Huey, your request for production of documents, the second set of production of document requests that entail 90 some odd, there is a point where both sides have the right to obtain information that's necessary in preparing their case for, for hearing. But there is a point where the court finds that the discovery process can be abused, and as a result of that, I'm going to give the petitioners 30 days to respond to your discovery requests, and if they have an objection to it, then they may do so. Any further discovery requests, if Mr. Osborne and the petitioners find that that is excessive, then they will be able to file a motion to quash those discovery requests. Discovery requests are intended not to be punitive in nature. They're intended to allow you to obtain information. But 90 some odd requests for admissions, or a request for admission is just basically saying you admit the following to be true or false, or deny it. And it's oftentimes used in a method to try to force the issues, but I am of the opinion that 90 requests for admission, is that what they were, requests for admission?
Yes.
May be excessive under the rules, but in any event, we'll give them 30 days to file a response and either object or provide the information requested.
Your Honor, if I may, I just want to clarify, they were not meant to be excessive. They were directed toward issues that the plaintiffs themselves had placed on issue, including offsets, reimbursement claims, property expenses, accounting issues, ownership issues, and factual assertions. So I was simply seeking clarity. I was not intending for them to be overbroad or excessive.
All right. I'm not saying that they were excessive, but I'm just saying that there is a point where you become, it becomes excessive when you're in a discovery process. So just be careful to make sure that that doesn't arise. And Mr. Osborne, being the good lawyer he is, will file an objection to them if he believes that it has become excessive. All right. Then 30 days to respond to the discovery responses. The court finds that the motion to establish a buyout procedure, authorize transfer of interest, impose deadlines is denied.
Thank you, Judge.
Thank you, Ms. Huey.
Thank you.
This courtroom battle just got intense. Miss Huey begged the judge for a faster way out of a messy property dispute, saying she's been stuck paying thousands every month while her money stays tied up in the house. But the judge shut it down fast, reminding everyone the court already approved a plan to sell the property, and changing it now would only create more chaos. Then things got even wilder when the judge called out her 90-plus discovery requests, warning the court process could be turning excessive. In the end, the judge denied her motion completely and ordered both sides to move forward with the original sale plan. What do you guys think? Was the judge being fair, or was Miss Huey getting blocked at every turn? Drop your thoughts below, and don't forget to like, comment, and subscribe for more courtroom drama.